Are you recommending that people aggressively make gifts? I mean, right now we've got a $5 million gift tax exemption equivalent.
Yes, we are recommending it, and we have people doing it. A $5 million gift for husband and wife, that's a $10 million gift. You couple that with some discounting, you can probably give away, actual value more than that. And once you've made the gift, you've also gotten the appreciation out. And one of the things that's unfortunately historically going on right now, we have some very depressed real estate values.
Yes.
And people are taking advantage of these low assessed and appraised values and discounting them, thinking, well, I'll get this out of my estate now. I don't need it. My kids and grandkids are going to reap the harvest when the market recovers, when the property may not be leveraged. They may be able to hang on to it more or less indefinitely, and the downstream it'll recover. So yeah, there's a lot. You can pack a lot of value into that $5 million exemption. Now, there is a downside to doing this, and this is a very technical issue, and it's a little bit scary, but it hasn't stopped us from recommending to our clients to go forward with substantial gifting, nor has any client, when confronted with this problem, decided not to do it. And that's the same problem of the exemption potentially automatic, not even potential. Right now, the law is it will revert to $1 million in 2013. And that is technically what happens if you give a $5 million gift, you file a gift tax return, you use up your exemption, there's no tax due on it. But when you file a federal estate tax return after your death, or your executor does, you add back in to the taxable estate lifetime taxable gifts. So that $5 million comes back in.
Right.
If the exemption is still $5 million, you're fine. If the exemption's for some reason gone down to $1 million, that delta, that $4 million, we call it, gets clawed back into your taxable estate, and it's subject to estate tax. Mm-hmm. Now, that's not what anybody intended when they changed these rules. And it's a technical problem. And we're expecting that there'll either be some legislation or if they make the tax permanent, it'll go away. But that's a potential problem with making these large gifts now, that it might come back later and cause a problem in the estate planning that's done because of all of a sudden a significant tax. In fact, take the worst case scenario, that's $4 million at 55%. That's what, $2.2 million of tax that somebody's got to come up with that wasn't anticipated. So that's a problem.
Now, what if you had somebody that came to you and they had a $5 million estate? I mean, let's just say they had $5 million of property. They're trying to do an estate plan, and they come to you and they say, should I make this $5 million gift? What would you tell them?
If that's all they had?
Yeah.
Probably not. I mean, if they could probably make modest gifts. I mean, if there were, they had grandchildren they wanted to fund college for them, I probably wouldn't have them do it. The people that are making the $5 million or $10 million gifts probably have $40 or $50 million worth of assets, and they're getting those kinds of numbers, out currently.
So you need to use common sense when you're doing
Oh yeah, and well, unless the person wants to give it all away and go join a monastery or something, but
that's sort of the extreme.
Mm-hmm.
Okay, well, we've talked a little bit about this portability stuff. Mm-hmm. Is there a risk to portability?
Well, believe it or not, yes, there is. It's the same risk, slightly differently explained, but it's the same problem as this clawback rule. And that is that I leave my $5 million exemption to my wife, mm-hmm. and that's fine. Now it comes time for my wife to die, and the exemptions are back to $1 million. She only gets $1 million exemption on her estate. I've wasted my $5 million exemption. Mm-hmm. It's gone. It's just not there. It's the same problem because that's all she gets is $1 million. And the other issue that's I think there is some corrective legislation, or there's maybe some rulemaking that's going to happen, and that is to elect this portability, you have to claim it on a timely filed federal estate tax return, even if the federal estate tax return is not otherwise required.
Right.
So we think they're either going to come up with a Form EZ that all you do is claim this portability thing,
Because we were saying this is going to be the mother lode for all tax return preparers.
Oh, yeah.
Now we're going to have to prepare estate tax returns when there's no estate tax.
When there's no estate tax for smaller estates in order to claim this portability thing. So this may or may not get solved, but that risk is there. And in fact, in our minds, in terms of planning, if someone does die in these next 2 years and you're trying to capture this estate tax exemption, which that is in stone if someone were to die, that $5 million estate tax exemption, we would normally capture that and put it in, a credit shelter, bypass trust, and we still think you should do that. You've got it. You're not exposing yourself to this possible problem. Plus, it's in a trust, and so it's going to be. You can exempt it from creditors. It's going to be. It has more benefits than it has downsides. So our plan is to continue to capture exempt amounts, put it in trusts in our sort of traditional way we've been doing it for years, and keep that exemption trust alive and not just rely on portability. There may be a circumstance where portability is going to work, but that seems, at least from our perspective, would be a preferable way to do it.
So there are some people, of course, that still have these bypass trusts from years gone by. And some of them are saying, well, gee, it's got a $5 million exemption. Maybe I should just get rid of that bypass trust. Well, what do you think about that?
Well, we've done a few of those. There's a couple of different ways to go about doing that. It sort of depends on your clients and their tolerance for risk. Because most of the time you'll look at a bypass trust and you'll see there's a provision in there that allows either the trustee or the surviving spouse to withdraw principal for support. And it's a special standard that's in there. And if you have a situation where the bypass trust is not needed, then what you can do is you can have the trustee exercise his or her discretion, determine if there is support need, and basically withdraw all the assets from the bypass trust and stick it over in the survivor's trust. Now you can do that, but you got to do it with notice, and you want to do it with consent of all the beneficiaries. And most of the times we do, it's a relatively small, these are probably under $1 million trusts, close-knit families, everybody's on board, not a big deal. It's a bigger issue, more money, more risk. You can actually go to court and achieve that result. There are code sections that will provide you that extra measure of protection, and then you get a court order, and you should be completely clear of any liability for doing that. But that's an easy technique.
But now you're eliminating the potential benefits, though.
Well, I don't need it. That's the point.
If you don't need it.
I don't need it because the exemptions, maybe the exemption's big enough. The other thing that happens too is that in a bypass trust, when the second spouse dies, you don't get a step up in basis in the assets.
Right.
So if you move, those happen to be, maybe that's a principal family residence or something, and you move it back over to the survivor's side, when the survivor died, that's in the survivor's estate, it gets a step up in basis. So there can be tax benefits to getting rid of the bypass trust if it's not needed for estate tax purposes. So that's one technique. Moving forward in this arena, this is one of the areas where you can use that trust protector. You can have the trust protector have the ability to collapse all this or change it if necessary. So that's one way to do it. But if we go back, we've got bypass trusts way back when the exemption was $600,000, and maybe has $700,000 or $800,000 in it now, and it's a giant pain because of the reporting and counting and everything else that goes with it, and the family doesn't want it. And of course, more frequently than not, I get what I'll call the self-help resolution. You discover the surviving spouse has already withdrawn it all and just completely ignored the formalities of the trust.
Well, that happens a lot anyway. So,
so that happens too.
Okay. Well, we're actually getting where we're sort of running out of time here. So I think what I'm going to do is just let you offer maybe words of wisdom to people related to estate planning for the next couple of years. Well,
I would say anybody that is thinking of doing estate planning, don't sit and wait. There are some significant opportunities now. Get in, see your planner, see your tax person, get to the person who understands this and can sort of get you through this minefield. It's not only a minefield, there's also a lot of fruit out there that you have the potential of using to your benefit, and get in there and get it done. And you can build plans that are flexible enough to adjust to a changing tax scenario. Because before, we had all these tax issues. This is planning your estate. This is getting your assets where you want it to go when you're gone.
Right.
That's the primary goal, that result. And then you try to do it in a tax effective way. So you still want to get that primary goal achieved.
Okay. Well, Jim, thank you again for being my guest today.
Thank you, Mike.
And such a pleasure having you, and your fountain of wisdom, and particularly dealing with such a complex area that so many people are wrestling with these days. And so it's good to have you here in our community. And so, folks, I hope we've given you some food for thought here. And if you have not taken care of your estate plan, now is a good time to get in there and meet with your attorney and find an attorney if you don't have one already. Got an excellent one here with me. And anyway, we'll see you next time on Financial Insider Weekly.